Good evening, everybody. Welcome to tonight's estate planning program, Big Changes in Connecticut Trust Laws and What They Might Mean for You, with attorney Erin Duquesne. My name is Ann Thompson, and I'm the Assistant Director for Public Services here at the Essex Library, and I'm honored to welcome attorney Duquesne back to our Zoom stage. I've launched a poll, as you may see. I'm asking you to give us whoever might be sharing your screen with you tonight so that we can give some accurate statistics back to the Connecticut State Library at the end of this fiscal year. They ask us to tell us how many people have come into our program. So this would be a huge help if you can just let me know if there's anybody else sharing your screen with you tonight. And I appreciate your submitting those answers. While you're doing that, I'm going to go over a few of our housekeeping rules. We do have a large group registered tonight, about 76 or 77. So in order to maintain that precious bandwidth, please keep your cameras off and your microphones muted so people can get great audio quality from the program. I would also like to ask you to go ahead and feel free to put your questions into the chat as you think of them. And Erin will be breaking in the content sections of her presentation to stop and ask for questions, but go ahead and put them in the chat if you think of something, even if it's off topic within that one section of the presentation, and we'll get to them all. And with that, I'm gonna end this poll. Thank you very much for your responses. We'll get this out of here. Everybody's done. Thank you. And Erin, you'll have to take that poll down. There you go.
Okay.
And with that, attorney Duquesne is an estate planning attorney with the law firm Sapega, Daly, Pope, and Perry, and is based in the firm's Madison office. She is a member of the Connecticut Bar Association Elder Law and Trust and Probate sections. She lives in Madison with her family and serves the Madison community additionally on the town's Board of Selectmen. Erin, thank you for joining us again. I have put in the announcement that your previous session with us on basic estate planning is up on our YouTube channel, and people can go click on the link afterwards and watch that. Thank you very much for joining us tonight.
Okay. Good evening, everyone. And thank you for coming to tonight's presentation during this busy holiday season. As Ann mentioned, my name is Erin Duquesne, and I'm with the law firm of Sapega, Daly, Pope, and Perry. And I practice exclusively in the areas of estate planning and elder law, as well as planning for families who have family members with disabilities.
Her audio, but that's not what we're worried about. It's her audio.
I think somebody's not muted. Oh, okay, now you are. Okay. So just to give you a sense of what I'm thinking for the agenda for this evening is that I'm going to talk a little bit about what probate is, because I know that's kind of a big topic that there's a lot of buzz about. And then I'm going to talk about trusts, what trusts are, and why they're used. And then we'll get into the topic of trust laws and what's some of the changes that have happened over the last couple of years, or as of last year. So I'm getting all kinds of things. Okay, so to start with, the question is, what is probate? So I have a lot of clients who come in and they're all excited about probate and avoiding probate. So I wanted to touch upon this. Probate is really, it's the process by which a solely owned asset is transferred to a successor owner. So if a decedent dies and they own something in their name alone, the only way that it can be legally transferred to another owner is if it has to go through the probate court process. Oh, somebody is not muted. I'm not sure. Okay. So if a decedent dies and they don't have any assets that are solely owned, they won't need probate. So what are non-probate assets? These are assets that do not require probate to be transferred from a decedent to a new owner. And I don't know if you can mute people if they're not muted from your screen.
Hi, Erin. Sorry about that. Yes, if everybody would please keep their microphones muted, that would be wonderful. Thank you.
Okay. So I have a lot of clients who are sometimes confused by this idea. They think that a will is going to govern how assets pass upon all their assets pass upon their death. I've listed here some of what I call
Where's the volume on this thing?
Okay, I'm just, if everyone could just mute their microphones, that would be really helpful because I'm hearing a lot of sound. Okay,
Yeah,
so
sorry, Erin. I think the issue is folks who are not as well versed in Zoom.
Sure.
There's a difference between your microphone and your speakers. And so if you turn on your microphone, you're actually speaking to the rest of the people in the program. If you're not hearing what you want to, it's probably because your speakers on your computer or your device are off. So turn your speakers on, but keep your microphone off, please.
Okay. And similarly, someone just said they can't see me. So there should be a little icon that looks like a camera, and that needs to be also turned on your screen in order to be able to see me. So I hope that helps. So assets that do not require probate in order to be transferred from one person to a beneficiary. So if you die and you own assets jointly, as many couples do, joint with right of survivorship. So oftentimes we see this with homes and bank accounts, checking accounts, brokerage accounts. When someone dies, that asset goes to the joint owner, passes to the joint owner by operation of law. No probate court is required in order to effect that transfer. Assets such as retirement accounts that have beneficiary designations also do not require probate. They pass by way of beneficiary designation. So it's very important that you make sure that your accounts have both a primary beneficiary and a contingent or secondary beneficiary, so that if your primary beneficiary predeceases you, that there is an answer for where those assets should go next. I find sometimes that clients definitely have a primary, which is usually spouse if they're married, but sometimes don't have a secondary. So that's something to check on just as a practical matter. The other types of assets that may have a payable on death designation, or which applies to checking and savings accounts, and brokerage accounts, investments accounts often may have a transfer on death designation, which operates like a beneficiary. So if you name a transfer on death beneficiary of a brokerage or investment account, when you pass away, that asset's going to transfer to the named beneficiary without requiring the probate court getting involved. The other type of assets that are not probate, they do not require probate, are those assets that are in a revocable living trust, which I will discuss in a minute. Okay, so what's the big deal about probate? And it's got this reputation that's a terrible process, and sometimes it can be. Probate in Connecticut, there are 3 different types of probate, and it really depends on the assets that are owned by the decedent at the time of their death. So we have a full estate is required when someone owns greater than $40,000 in probate assets. So those are not the non-probate assets, it's the probate assets, the solely owned assets, or if they own real estate. The full estate is a multi-step process. It's prescribed by statute, and it involves a number of steps, including naming the executor, opening the estate for the purposes of creditors being able to come forward and file claims against the estate. Accountings have to get, inventory has to get filed. And then the final distribution has to get approved. So it's kind of a full process. It can take 6 to 12 months. So it can hold up assets from passing from the decedent to their intended beneficiaries. There's also a small estate. The small estate is when you do not own real property and your assets are less than $40,000. So often I might see that an individual might be a joint owner on most of their assets, but perhaps they have a car and a savings account. And in order to be able to transfer ownership of that car, it may require that a small estate be opened with the probate court. So that's a much smaller process. Then there's what we call the tax purposes only estate. And that is required typically when, it technically always is required. But what happens is that when you die and you own property or an interest in real property, even if it's a joint interest, the state of Connecticut will put a lien on the property because there's an assumption that estate tax is owed by the decedent. Now, estate tax is owed only if you own assets greater than the estate tax exemption, which is currently $7 million in the state of Connecticut. But in order to get that lien lifted or released, you have to file what's called a 706 NT, which is no tax owed. So it's an estate tax form that gets filed with the probate court, where you report your gross taxable estate. Your gross taxable estate is anything that you own solely and your interest in joint property. And it's that once that's approved by the court, then that lien, you're issued a release of lien, which gets filed on the land records. Why is this important? Because if you want to go and sell the property, or if your decedents, your beneficiaries, your children want to sell the property, the title needs to be clean. And in order to be clean, it needs to have that release of lien on there. So this idea of probate being a terrible process, it can be. And why is that? Well, sometimes if the decedent is not organized, doesn't have their files together, and an executor or a child comes into it and is having trouble finding everything, that can kind of delay the process and it can be difficult. If family members don't get along, that can be another complication with the probate process. And also, it also depends on what types of assets are owned. So for example, business interests, timeshares, those types of assets are a little bit more difficult, require certain documentation, and they can also create more work in the probate process. So with the estate tax return, that's how the probate court calculates its fees. So what it does is it takes the gross taxable estate number and it will calculate fees, its probate fees of what has to get paid, which is typically about 1/2 of 1% of the total assets. The probate courts in Connecticut are funded by these fees. So this is a way for them to collect by putting this sort of invisible lien on the property. Okay. So next I want to jump to this an explanation of what is a trust. So a trust is an entity that's created by a written agreement between the trust maker, which is called the grantor, or the sometimes it's called the donor or the settler, and the trustee. And so many times when people are creating revocable trusts, the grantor and the trustee are going to be the same person, because that allows the person to maintain control and access of their assets during their lifetime. The other party in the trust is the beneficiaries. So those are the people who are entitled to distributions from the trust. Sometimes, and during the grantor's lifetime, it can be all three, because you're going to have the grantor will also be the beneficiary during their lifetime. They'll be able to make distributions to themselves. So the trust contains the rules of how those assets should be managed and then ultimately distributed at death. So in that way, it operates like a will, except it does not go by the rules of the probate court. It goes by the rules of the trust. And the trust will avoid, so assets that are in the trust will avoid having to go through the probate process in order to be transferred to the ultimate beneficiary. So just wanted to review with you the different types of trusts. We have testamentary trusts. Those are the types, those are trusts that are created under a will. So they're embedded in a will. So for example, if I draft a will and I have minor children, I will probably include provisions that would say that I'm leaving everything to my spouse. If my spouse predeceases me, I'm going to leave everything in equal shares to my children. However, if those children are under 25, then I would like that money to go into a trust for them because I don't want them to inherit everything outright when they turn 18. So I'm creating a trust under the will. The trust doesn't get created or doesn't come into existence until I die. It's just sitting in the will, and then it gets created once my estate gets opened. The trust terms can be modified at any time because they're part of my will, and I can always change my will at any time while I'm alive. One of the key distinctions between a testamentary trust or trust under a will and a trust underneath a revocable or irrevocable trust is that there's probate court oversight over the trust. So if I die and my children are under 25 and a trust gets created for them, the probate court is going to have oversight of that trust. So the trustee, whoever it is that I've named, is going to have to file accountings with the court, annual accountings, and the court is going to review and have to approve the accountings. The other types of trust, there's two types of living trust. One is called a revocable trust. The revocable trust is the type of trust that operates much like a will, in that it says what happens to your assets when you pass away. But the revocable trust can be changed and revoked, unlike an irrevocable trust. So if I create a revocable trust during my lifetime, I still maintain complete control of the assets, and I have complete access to them. And then when I pass away, that trust becomes irrevocable. It becomes a separate entity with its own tax ID number. And because of that, those assets can pass under the terms of the trust from the trust as its entity, as an entity, to the beneficiaries that I've designated within the trust, avoiding probate. The other type of trust is an irrevocable trust. So an irrevocable is similar to a revocable in that after I die, it's going to dictate where those assets that are within that trust, to whom they go to. So it's similar in that way. But during my lifetime, if I create an irrevocable trust, it cannot be revoked. And although it can be modified in some circumstances, which I will get into a little bit later. But the key difference, another difference between the irrevocable and the revocable, is that I will be relinquishing control of the assets. And many times I will be relinquishing access to the assets. And I'll go into the reasons why I might want to do this in the next slide. Okay, so just to kind of distinguish between the revocable and irrevocable. So why would I want to create a revocable trust? So most commonly it's used to avoid probate because my assets will not have to go through the full probate process, will not have to, they will be able to transfer to the beneficiaries faster. The other benefit to the revocable trust is that if I own out-of-state property and I have a will, then I will need to have an estate here where I live, and then I will have to open up another estate where that other property is. So I'll have to open what's called an ancillary estate. So many times when we have clients who have real estate in other states, we will recommend a revocable trust. The other reason that sometimes people like to do a revocable trust is for privacy purposes. So when you file a will with the probate court, then it's a public document and anybody can see it. So not only do people might not want their neighbors seeing it, but perhaps you don't want family members seeing it. So when you have a trust, there's more privacy. That has been changed a little bit by the trust code, which we'll talk about later. But in general, it would keep your affairs more private than in a probate court setting. The other reason is for incapacity planning, because when you create a revocable trust, you're going to name a successor trustee. So if I create a trust and I'm controlling my assets, I'm taking things in and out of that trust, and I become incapacitated, my successor trustee can immediately step in and start managing those assets and using them for my support and care. So it's a way to kind of plan for that situation. The other reason, I'm sorry, is for tax planning. So, and by that I mean estate tax planning. And that's for people who have estate tax exposure because their estate is going to be over the exemption limit, which at the current time at the federal level is about almost 12 million, and at the state it's 7 and going up to 9. So the irrevocable trust, that is a different type of trust, and it's used for different purposes. One is to protect assets from creditors. Another is for long-term care planning. So if an individual wants to transfer assets out of their name because they're anticipating that they might need long-term care in the future, we can create an irrevocable trust where they can transfer the asset. And many times for clients, it's a home, and they can still maintain some control over that asset, what happens to it during their lifetime and what happens to it after death. And as long as it's within that trust for 5 years, it's not considered theirs for the purposes of Medicaid eligibility. So we do a lot of those types of trusts. One thing that I find is that we have clients who have revocable trusts who think that they've got asset protection. And that's not the case, because with the revocable trust, you're creating that mainly for those reasons that I've stated, but you're still wanting to maintain access and the right to use those assets. And so that would be considered a revocable trust. One point that I wanted to make to everyone is that not everyone needs a trust. So for example, if I have a client who has one child who's financially stable, the child's going to inherit everything outright. The client owns a house, bank accounts, they've got beneficiaries on all their retirement accounts. They may not need a revocable trust because they're not going to have a big estate. There's not going to be any family issues because they've got one child. So again, you have to really kind of look at your specific situation and look at some of the reasons why a revocable trust might be a good idea. Okay. This is the point I was making before, know your trust. So just because you have a trust doesn't mean that it's protecting your home or whatever assets you have in it from the cost of long-term care. It's really only a special type of irrevocable trust that does that. So that's something I just wanted to emphasize with people. I'm just taking a minute now. Someone asked me about the difference between creating a trust and a foundation. I don't have a lot of experience with creating foundations. So that's not something I could really speak to about whether or not it's difficult to set up. Apologize for that. Okay, so any other questions, feel free to type them in on some of the things that I've gone over. Because my next topic is to kind of switch over to the Uniform Trust Code. So the Uniform Trust Code was adopted January 1 of 2020. And it is, so what happened is, so Connecticut had, there were laws, some common laws also about trusts and how they operate. And Connecticut adopted many sections of the Uniform Trust Code. So it codified rules on how trusts need to operate. It created defaults about how trusts operate, some of which can be overridden in the terms of the trust, and some of which are mandatory. So it establishes these rules about how trustees have to, what trustees have to do, and how the trusts have to operate. So it applies to irrevocable trusts. So trusts that become irrevocable after January 1st, 2020. So that could be a revocable trust. So if you created a revocable trust prior to that, and you pass away after January 1st, 2020, that trust becomes irrevocable after that date. So this trust code is going to apply to existing revocable trusts. It's also going to apply to irrevocable trusts that get created after January 1st. So the Medicaid Asset Protection Trust that I was talking about, insurance trusts, charitable trusts, all those that get created after January 1st, if this will apply. Okay, I'm just going to pause here because I got a couple more questions. One is, what is the 5-year look back period? The 5-year look back period is if a person needs to apply for, or a person needs long-term care. So if they need either to go into a nursing home or they need care at home and they want to apply for Medicaid or Title 19, the state in that application process is going to ask whether or not the person transferred assets out of their name in the 5 years prior to application. And if the person did, then there's going to assess a penalty period during which time they will not pay for the person's long-term care. So that's what that 5-year window is. So if somebody is anticipating wanting to transfer assets, to the best of your ability, what you want to do is you want to transfer them with the expectation that you're not going to need long-term care for the next 5 years. So that's that 5-year look back. Someone asks, how do you avoid ownership of a car from going to probate? So there's two ways. One is if you own it jointly with someone else, because then it would pass to the joint owner by operation of law. And the other way is actually quite easy. On the back of the registration form of your car, there is a place where you can write in a beneficiary. You have to do that and sign it in front of a witness, and the witness can't be the person who's going to get the car, but that would avoid having to probate it. And it's not the title of the car, which is a little, you would think it would be the title, but it's the registration. Okay, so the Connecticut Uniform Trust Code is a very, the laws are take up multiple pages, and so the intent of this presentation really is to highlight some of the kind of more significant ones that may apply to more people. One is the notice to beneficiaries. So when we talk about the probate court process, we talk about probate oversight. So the court is ensuring that the person's wish, the decedent's wishes are carried out in accordance with the will, and they're approving the inventory, and they're making sure that those assets get to who they need to be. So with a trust, we are avoiding probate. But the flip side of that is, who is going to make sure that the grantor, the person who created the trust, that their wishes get carried out? Because if we're avoiding probate, we don't have this body overseeing the trustee. So and clients will ask me, well, how do I know that things are going to get carried out according to my wishes? So really, trusts are in a way self-policing, because it's the beneficiaries that are going to question and challenge the trustee if the trustee isn't doing what they're supposed to do. So one of the main purposes of adopting the Uniform Trust Code was this idea of transparency to beneficiaries, because if a beneficiary doesn't know they're a beneficiary and doesn't know the certain provisions of the trust that apply to them, then they're not necessarily going to know or be in a position to be able to challenge a trustee and what the trustee may or may not be doing. So with that, trustees are required to provide written notice to beneficiaries when an irrevocable trust is created. So if you have a revocable trust that you've created, upon your death, it becomes irrevocable. So all the beneficiaries have to be notified at that point of the trust. Now, if it's the distributions are going outright to beneficiaries, this really isn't a big deal, because they're going to get notified anyway. They're going to get when the assets get distributed to them. However, if you've left things in trust for a beneficiary, which sometimes happens, then they have to be notified that this trust has been created for them. Also, when someone accepts the position of trustee, they have to provide notification to the beneficiaries that they are now the trustee of the trust. When a trustee resigns, they also have to provide written notice. And they also have to provide notice to the beneficiaries of their right to request a trustee report. And they have a duty to respond to inquiries from beneficiaries about how the trust is being operated, how the investments that are within the trust, how they're doing, what types of disbursements the trustee has made, and any liabilities that the trust may have. So they have to really keep the beneficiary informed. Now, sometimes a grantor may not want the beneficiary to receive these notices. So for example, if I have a revocable trust, and within it, I'm leaving everything to my children, but one of my children is a spendthrift, maybe has substance abuse issues, and I don't want them to know that they're the beneficiary of a trust. I don't want them to know what's in the trust. I don't want them to have that information. Or perhaps if I have a beneficiary who has cognitive disabilities and is not capable of understanding or acting upon this information. So in those types of cases, the code says that you can name a designated representative to receive the notices on behalf of the beneficiary. So if a lot of times in the situation where someone might have a spendthrift beneficiary, they're going to need to name a trustee for their trust. And so a lot of times it becomes the sibling. And there's another reason why they wouldn't want that the trustee beneficiary to know about or to get these notices, because then they're going to be relentlessly bugging their trustee sibling, perhaps for money. So it can get tricky, and you can designate it has to be it can't be the trustee. You can designate another person to receive the notices on the beneficiary's behalf. And that sort of addresses that issue. Somebody asked, is the 5-year look back the same from state to state? So the Medicaid laws are established by the federal government, and the states have the jurisdiction to administer Medicaid, to administer Title 19. So there are states that vary. Rules do vary from state to state. So whenever I have clients ask me about the rules in other states, I typically would suggest that they look into that state. So for example, Connecticut has a home care waiver program. So it allows Medicaid dollars to be used to pay for care at home instead of the nursing home. And that's something that Connecticut has, and many other states have, but some don't. So you really have to look into the rules of the particular state. Someone else asked, can 2 trustees be named? So yes, you can have co-trustees of a trust, and you can also indicate how you want those 2 trustees to work together. So before the code, the Uniform Trust Code, there was the presumption that there had to be, everything had to be done unanimously when the co-trustees did something. Now that's no longer the case. So if this provides a good example, is if your trust, if that's something that you want in the trust, then you need to make sure that you include that. But generally speaking, we have when we have 2 trustees, we will specify whether they're going to act jointly. So in other words, they will have to both sign off on everything. They have to act together, or someone might want them to act severally, in which case they have to agree, but one can bind the trust. They don't need both signatures, which from a practical perspective can be a little bit easier for trustees to manage. So at what age do beneficiaries need to be informed? So if they're under 18, then they're going to be, it's going to be their guardian that gets going to get the notices. So really the notice requirements apply to everyone. It's just that if you're under 18, it would go to a guardian. So the designated rep cannot be the trustee, because again, the purpose of that person is to keep eyes on the trustee. So sometimes that can be tricky if somebody doesn't have a lot of options of people to designate, but it's something to think about. Okay, so the new trust code also says that trustees must now provide beneficiaries with an annual report. So this annual report is not the same as a formal probate accounting that must be filed with the probate court every year for a testamentary trust. It's really an informal report that has to do with identifying what assets are in the trust, identify if there's been any appreciation or depreciation in the assets, have there been any disbursements or expenses that have come out of the trust in the prior year. So for example, housing expenses, distributions to a beneficiary, if a trustee compensated him or herself, those are all things that would get reported in this annual report. Let's see, and again, this applies to irrevocable trusts created or after January 1st, 2020. So there are quite a few provisions that are that can be overridden by the terms of the trust. So the UTC is creating default rules, many of which can be overridden, but there are rules that are mandatory. So a lot of the notice requirements are mandatory because again, the purpose is to provide transparency to beneficiaries. Some of the mandatory rules also include duty of loyalty. So a trustee has to act into the best interests of the beneficiary, and they have to act consistent with the intent of the grantor. And this is something, these duties have always been in existence. They have to administer the trust as a prudent investor would. They have to act in good faith and consistent with the terms of the trust. And they have to keep the beneficiaries informed in the ways that I just described. They also have to respond to a request by a beneficiary or a designated representative who makes a request for information about the trust. The UTC also includes provisions that allow the court to modify or terminate a trust in certain circumstances, which I will get into, those cannot be waived. Then there are a bunch of defaults that are not mandatory that need to be addressed in the trust document itself. And that includes things like provisions regarding trustee removal. So if you have certain wishes with regard to how beneficiaries can remove a trustee, then those need to be identified in the trust. And also co-trustees are going to be presumed to act by majority. So they need to agree, the majority of the trustees need to agree unless you've stated otherwise in the document. So those are just two examples of the non-mandatory provisions. Someone asked, can you review how to place your house into a trust? Certainly. So that's a pretty simple process where you would, someone would prepare a quitclaim deed and deed the house from the current owners to the trustee of the trust. That then gets filed on the land records in the town or the city where the property is located. But just to get back to that point, trust funding is very important. So I have clients who come to me with revocable trusts that were created years prior, and there's nothing in them. So again, if we're creating trusts because we want to avoid probate, or we want to create trusts for beneficiaries underneath the revocable trusts, we're going to want to make sure that there's assets in those trusts. And so if there isn't, then you can certainly, what we do is we prepare a pour over will in conjunction with a revocable trust that pours the assets into, it directs the court to pour the assets into the revocable trust if they're not already in there. But again, if you're going through the exercise of creating this revocable trust and you're trying to avoid probate, and that can be done simply by just making sure that your trust gets funded either at the time of creation or prior to death. And so we, in addition to creating a trust document with clients, will review every asset that they own and decide what should happen to it, and whether it should stay as it is or whether or not it should be retitled. Okay, another important aspect of the Connecticut Uniform Trust Code is this concept of new protection for beneficiaries. So as I mentioned before, there's many reasons why someone might want to leave money in trust to a beneficiary. It could be because again, because the child is a spendthrift, the child has substance abuse issues, perhaps the child has a disability and they qualify for public benefits, and their eligibility is dependent on their assets, so their means tested benefits, and they need to, those assets would render them ineligible if the child was to inherit them outright. So we created what's called a supplemental or special needs trust in that case. If someone's concerned that their child might get a divorce or has creditor exposure, perhaps is in a high-risk profession, those are the types of situations where people might consider leaving money in trust to a beneficiary. So there has always been an ability to create this insulation from creditors within a trust for a beneficiary. But the UTC codified and defined what's called the spendthrift clause that will insulate trust assets for beneficiaries, both voluntary, protects from voluntary or involuntary transfers. So creditors cannot get at the assets that are within the trust. Now, prior to this legislation being passed, what we typically would do is create, in order to get that creditor protection, is we would have an independent trustee who would be responsible for making distributions at their discretion. And that way, a beneficiary could not compel distributions, and the creditors couldn't get access to those funds. The new law allows a beneficiary to be his or her own trustee, and to be able to make distributions for health, education, maintenance, and support. So this is often a good solution for someone who wants to provide protection for their son or daughter who may or may not have credit or divorce, but they're not concerned about spendthrift tendencies of that child. And they would prefer that the child had control and access to the money that they've left them in trust. So it sort of gets the best of both worlds. The child is still allowed to have that control, but still maintain that creditor protection. Okay. Okay. Someone asked, does the language of a revocable trust created before 2020 need to be modified to incorporate the new UTC requirements? So if you have a revocable trust that was created before this time, but it's going to become, inevitably, it's going to become irrevocable after the date. So these provisions are going to apply to the trust. So yes, it's a good idea to incorporate some of the new mandatory requirements into the trust. That way the trustee knows that, they're going to have make annual financial reports to the beneficiaries. If you want to identify a designated representative, and also to review that trust to make sure that if there's any presumptions that used to be in place that are no longer, that you're addressing them within the document. So it certainly would be good to review your trust and make sure that it still is going to do what you want it to do. If you don't include provisions requiring a trustee gives notice to beneficiaries, that's still a requirement whether or not you include it in the trust document itself, but it would give additional direction to a trustee that they have to do that. Someone asked, should your long-term care policy be listed in your revocable trust? That would not be an asset that would go into the revocable trust. If the long-term care policy had some sort of a payout, you would probably have a beneficiary on that, but it's not an asset that you would title in the name of the trust. Someone asked, can I set up a trust for a disabled child without funding it and fund it through a revocable trust upon my death? So yes, you can absolutely do that. So a trust created under a revocable trust, either for a disabled child or just for a son or daughter who you want to provide creditor protection to, that trust, the trust for those beneficiaries don't actually get created and funded until your death, because what your trust is saying essentially is that when you die, you want your assets to go to you name your beneficiaries and the percentages. So if I said I want my trust to go in equal shares to my children in trust, so the trustee is going to make the distributions, but they're going to create trust accounts for the children. If I've created a supplemental needs trust, either beneath my revocable trust or separately, and I don't want to fund it until my death, it would just, similarly, it would say upon my death, I want my assets to go in this way, and this beneficiary's assets are going to go into their supplemental or special needs trust for their benefit. And this would protect or ensure that they maintain their eligibility for public benefits. Okay. So this new beneficiary protection, creditor protection, is an important kind of component that a lot of clients are happy about, because some of them are not happy about having to name another trustee to take over. Okay, one of the other things that the code did was it made this requirement that a financial institution has to accept what's called a certification of trust as proof of the trust existing. So for example, if I want to open an account in the name of my trust, or I want to retitle it to the trust, the financial institution is going to want proof that this trust exists. Now, historically, they would ask for a copy of the trust. But if you think about it, the entire trust may have private information that maybe you don't want to share, and quite frankly isn't necessary to share with a financial institution. So now with this legislation or this new enactment, we can create a certificate of trust that has to have certain components, such as the name of the trust, who the grantor is, who the trustee is, what powers the trustee has, and their financial institution has to accept this as proof of the trust and not require a full copy. Okay, so modification. So irrevocable trusts can now be modified under certain circumstances. And so this typically would happen. So like I said, if I create a revocable trust, it becomes irrevocable upon my death. If I've created trusts for my children that are going to last for their lifetime, so there's no payout at any certain age, I want this money to stay in trust for their lifetime. A lot can happen over the course of someone's life. And sometimes there are circumstances that may require or may want, a beneficiary may want to alter the terms of the trust. And these are some of the reasons or the circumstances under which you can do that. So if circumstances have changed from the time that the trust was created, so for example, if someone created a trust for a child because they had substance abuse issues, and 20 years later, they haven't had these issues for 20 years, and the beneficiary says, I don't want this money in trust anymore, they could perhaps get the trust modified. Again, so this is relatively new law, so we don't have a lot of examples or experience with actually modifying this trust yet, or bringing this to courts. But it has been an area we've explored with some clients. Another reason you can modify a trust is if all beneficiaries consent to the modification, provided the change is consistent with the material purpose. What is a material purpose? So, and how does someone know what it is? So we typically in our trust now, since the adoption of this code, we will list certain things that are material purposes within the trust document based on the circumstances of the client, and we will make those clear so that the trust isn't modified in a way that's going to be inconsistent with the grantor's wishes. Sometimes the trust might need to be modified to correct a mistake, and this can be a mistake of law or mistake of fact. So it could be something that the settlor thought to be true, but didn't understand the law, and the correction or modification to the trust has to get made. If the grantor and beneficiaries all agree, so if this is a trust that's created and the grantor is still living, then the change can be made if it's even if it's inconsistent with material purpose. It can also be, the trust can also be changed if there are changes in the tax law and the trust needs to be modified in order to take advantage of certain tax benefits. Some of the ways, the options for modifying a trust they do require court approval, and some do not. But this is certainly is an opportunity for people who have old trusts to make modifications in under some certain circumstances. The other thing, and I'm just going to touch upon this, is that the Uniform Trust Code created the possibility for a domestic asset protection trust. So creates the ability for a person to put money into a trust to protect it from their own creditors. Before that, other states you would have to go to another state besides Connecticut to set something like this up. So this sounds like a great idea, but it also has its trade-offs, because by creating this type of trust, you're maintaining a right to income and up to 5% of the principal. So you really have to make sure that you have other assets to live on. And if you have if you're putting a lot of assets in, you're not going to have full access to them. You also cannot be the trustee of the trust. So you're giving up, you're relinquishing control over those assets. So we're really seeing that this sort of applies in limited circumstances, but certainly in a situation where someone might have be in a high risk profession, and they want to make sure their assets are protected. This can be a useful tool. You cannot create this type of trust and transfer assets if you have existing creditors, because that's considered a fraudulent transfer. So you can't use it for that purpose. Okay, so someone had asked me about what happens if you have an existing trust. What do you do? So again, a lot of the rules and requirements applies to revocable trusts that are currently in place that are going to become irrevocable after January 1st, 2020. Testamentary trusts. So if you've created a trust underneath your will, that's going to go into effect after you pass away. That's going to be affected. And irrevocable trusts that are created after January 1st. So your Medicaid asset protection trusts or other creditor protection trusts, those are going to be affected by the code. So types of things that you might want to consider is if your trust document doesn't include those notification requirements, you're going to want to make sure your trustee knows about them so that when the time comes, they will be fulfilling their notification responsibilities. You might want to name a designated representative if you do not want your beneficiary to be receiving those notices. So if you've set up these trusts for your children because of specific circumstances and you don't want them to know about the trust or to know what's in them, you're going to want to designate a designated representative. You're going to possibly want to review your choice of trustee. So if you've created a trust for your child within your revocable trust and you have in there an independent trustee because you wanted them to have creditor protection, now there's this opportunity to be able to name them as their own trustee and still have the creditor protection. And then again, if there are certain purposes that you want fulfilled by your trust and you don't want them to be modified, then you might want to include those specific material purposes within the trust document itself. So these are only some of the changes that may apply to trusts that already exist, or some things you might want to be thinking about. Certainly there are others. Again, the Uniform Trust Code is pretty expansive. So it would be worth reviewing the current documents you have. And that's the end of my presentation. And I think I've lost my my questions.
Oh, Erin, if you want to stop sharing your screen, you'll be able to go back to chat.
Oh, okay, I've got it.
Okay.
Somebody asked, can a disabled child be her own trustee in a special needs trust? And so the answer is no, because that person cannot have control or of the assets. It has to be somebody else. And I don't know what it says. So certainly if anyone else has any other questions on something that I talked about, or maybe if I didn't talk about it, you're certainly welcome to ask a question as well. Okay, are taxes from trusts or for either revocable or irrevocable filed on the grantor's taxes? So that depends if it's set up to be a grantor trust. So a revocable trust is typically a grantor trust. It doesn't have its own tax ID number, and the taxes, the income is taxed to the grantor. Once that the grantor dies and that trust becomes irrevocable, then the irrevocable trust would get its own separate tax ID, and there would be separate. They would be taxed at the trust rate. An irrevocable trust can be a grantor or non-grantor trust. We typically, when we create an irrevocable trust for the purposes of protecting assets in the event of needing long-term care, we create it as a grantor trust so that the assets can still be, or the income rather, can still be taxed at the grantor's individual trust rate and not the higher tax rate. So again, it depends on how the trust is, how it's set up. What are the Connecticut tax rates for assets over 7 million? So as I said, Connecticut has its own state estate tax. And if someone passes away owning assets greater than 7 million, which is going up to 9 million in 2022, then those assets will be taxed at a rate of between 10 and 12%, versus the federal, which is about 35 to 40%. If you die owning more than 11.7 million. Someone mentions this idea of a trust protector. So we always include a trust protector in our documents, and a trust protector is an independent party who is designated in the document, but who really is only called upon to act under certain circumstances. So the trust protector can kind of oversees the trustee. They can remove a trustee in some cases. They can make changes to the trust. So if there is a change in the law and the trust is no longer functioning as it was set up to, then a trust protector can revise the trust. So that's a really good point, because by putting in a trust protector, you're avoiding having to go to the court. You're avoiding the beneficiary having to go to the court in order to make those changes. You're allowing the trust protector. And then once the trust protector does what they need to do, then they sort of step kind of out of that role again, and until they're called upon if needed again. So a trust protector is a great tool. So I think, and I'm not sure if people have my email address, but I'm fine with people emailing me with questions as well. If someone thinks of something after the presentation, they can certainly email me.
Thank you, Erin. We'll definitely, as Erin and I discussed ahead of the program time, we'll be able to send out the PDF of the slides that Erin presented tonight, and included with that, I will put in Erin's contact information. If there aren't any other questions, we'll release you to your cold evening, hopefully at home. Thank you, Erin, so very much for presenting what is basically a fire hose of information of layered complexity in a very articulate and easy to understand way for all of us. And I having gone through the process with my parents and having written wills, I can't emphasize enough that having an attorney by your side when you do this is incredibly comforting, and there's really not a good way to navigate it without one. So Erin, thank you so much for bringing us your expertise tonight. And please, everybody, thank you for joining us, but also know that we'll be presenting with Erin again in the future with another topic, and hopefully it will be of interest to you. And I look forward to seeing you at another Essex Library program soon. Thank you all for joining. Take care.
Thank you very much.